There's some frequently asked questions about the Bagley-Keene Open Meetings Law. What are the three main open meetings law in California? These open meeting acts are generally referred to as Bagley-Keene, which applies to state entities, LOMA, the Legislative Open Meetings Act applying to the legislature, and the Brown Act applying to local entities. When was the state entities law adopted? Bagley-Keene, as it's known in the capital community, was adopted in 1967. What does the California Constitution say? It declares that the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. As a result, the state constitution mandates open meetings for state agencies, boards, and commissions. What is the intent of the Bagley-Keene Act? It provides that the people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control of the instruments they have created. What is the policy behind the Bagley-Keene Act? Well, Government Code Section 11120 provides a couple of provisions. First, it is the public policy of the state that public agencies exist to aid in the conduct of the people's business and the proceedings of public agencies be conducted openly so that the public may remain informed. In enacting this article, the legislature finds and declares that it's the intent of the law that actions of state agencies be taken openly and that their deliberation be conducted openly. In addition, the people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created. This article shall be known and may be cited as the Bagley-Keene Open Meeting Act. What is the notice requirement of Bagley-Keene Act? Notice of state agency or department meetings must be provided to any person who makes a request in writing at least 10 days in advance of the meeting. What is required in the particular notice? Notices must include a specific agenda for meetings, including the terms of business to be transacted or discussed, and no item may be added to the agenda after the notice is actually provided. What action can be taken on items not on the agenda? State entities may take action on items of business not on the agenda under certain limited circumstances, most notably upon a determination by a majority vote of that entity that an emergency situation exists. Where must the agency conduct its meeting? The Act prohibits a state agency from conducting any meeting or function in any facility which prohibits admittance to any person on the basis of race, religious, creed, color, national origin, ancestry, or sex. What is a meeting? In Government Code Section 11122.5a, it defines a meeting to include any congregation of a majority of the members of a state body at the same time and place to hear, discuss, or deliberate upon any item that is within the subject matter jurisdiction of the state body. What is a state body? Government Code Section 11121 provides that every state board or commission or similar multi-member body of the state that is created by statute or required by law to conduct official meetings is deemed a state body. How expansive is the definition of a state body? This definition applies to advisory committees and other informal bodies that advise California state entities. Excuse me. As a result, even a three-person advisory committee to a particular state department must follow the Bagley-Keene Open Meeting Act. What is an action taken? Under Government Code Section 11122, action taken means a collective decision made by the members of a state body, a collective commitment or promise by the members of the state body to make a positive or negative declaration, or an actual vote by the members of the state body when sitting as a body or entity upon a motion, proposal, resolution, or similar action. What has the Attorney General said about collective commitment? According to the Attorney General, conversations that advance or clarify a member's understanding of an issue or facilitate an agreement or compromise among members, or advance the ultimate resolution of an issue, are all examples of communications that contribute to the development of a concurrence as to action to be taken by that body. Are sessions allowed at all? Under Government Code Section 11126, closed sessions can be held only under very limited conditions, including appointment, employment, evaluation, or discipline, including the dismissal of a public employee, licensing, honorary degrees, real property negotiations, investments, and also to confer with or receive advice from legal counsel regarding pending litigation. And finally, what are the remedies for violation of the Bagley-Keene Act? If it is allegedly violated, the decision of the body can be overturned if challenged within 90 days under Government Code Section 11130.3, and violations may be stopped or prevented pursuant to Government Code Section 1130, and costs and fees may be awarded, and criminal misdemeanor penalties may be imposed upon a violation of the Bagley-Keene Open Meeting Law.